Good morning and welcome to Advocation's June webinar. The webinar topic is Understanding Your Obligations under Ontario's Human Rights Laws. Thank you very much again for joining. I hope that you are going to get benefit from this session. For those of you who haven't attended before or who aren't familiar with me, my name is Hermie Abraham, and I am an employment lawyer and principal with Advocation Professional Corporation. We are an employment law firm, and we help both employers and employees with their workplace issues. I develop Training Thursdays because I often get random questions from human resources professionals and company owners who are just curious about different areas of employment law and don't necessarily need to engage a lawyer to be able to answer these questions. So the purpose of these webinar series is to be able to provide answers to some common areas that I do hear these questions, and also to give employers the knowledge, the strategies, and the tools that they need to be able to have a more productive and a better functioning workplace. Training Thursday webinars are held on the third Thursday of each month at 9:00 a.m. And the webinars are for approximately 30 minutes, and they include questions and answers at the end. There's a new topic each month, and I try to cover a myriad of issues. So please do subscribe to attend the other webinars. And if you have topics that you're interested in, please let me know. I'd love to be able to address them in future webinars. Few housekeeping before we begin. I've been technologically challenged with webinars these days. So for one, I apologize to people who have auto-subscribed and received notifications for the July webinar. That was my bad. But hopefully I've massaged some of these issues and they won't be going forward. But we are using the Google Hangout platform, and it is sensitive to time. There's oftentimes a time delay. So when using this platform, you can pause the webinar, but note that if you do pause the webinar, you'll be able to pick up from where you left off, but you're not going to be live. So you're not going to be able to live poll or participate in a live manner. And I would love to be able to take questions throughout the webinar, but because of the delay and lag, it's easier to do questions at the end. So as you're thinking of questions, do submit them in the chat box. I promise I will attend to all the questions at the end of the webinar. So with that, we will get started. And I'm going to load my first poll. The reason I chose the topic of human rights laws is because I'm finding that this is an area where there's a lot more activity in terms of complaints or just issues employers have to deal with. The employees are also better equipped to bring a human rights complaint forward because I find that a number of employees have resources now which will help them bring a complaint forward. They don't have to hire a lawyer. There's a Human Rights Legal Support Center which provides free pro bono services to employees. There's also lots of tools that have been created by the tribunal to be able to help people work as self-represented litigants. So you do find there's an influx, more so than in court proceedings, there's an influx of people who are representing themselves and find it easier to do so. And as a result, you're finding employers who are dealing with many human rights complaints. As well, the human rights regime had a review about 6 years ago now. And one of the outcomes of the review was that there wasn't enough teeth in the system with respects to damages. So where before, if there was a violation of the Human Rights Code, employers could expect damages somewhere around the $5,000 range, maybe maximum $25,000. More and more now we're seeing damage awards that are far higher, some as high. The highest one, which was last year, is $200,000, and you're starting to see them in the hundreds of thousands of dollars. So these news items get out, employees think, oh my gosh, you know, I might have a case here, and then they become far more likely to want to bring a human rights case forward. So the purpose of the webinar is to be able to help you be able to deal with these issues if they do come in your workplace. And I see that, you know, about 80% of you have been very fortunate and haven't had a human rights complaint, but 20% have. And I have to say, from even just helping employer clients, sometimes they're, frivolous complaints, but you still have to manage them. And that's why I say that the most you can do to be able to make yourself knowledgeable and have systems in place to be able to address these issues before they happen, the better you are in being part of that 80% and remaining in that 80% that doesn't have complaints. So today's webinar, we're going to look at the laws that touch on human rights. We're going to also talk about the Human Rights Code specifically and your duties as employer. And then I'm going to pick apart some of the areas that you tend to see the most litigation for human rights, some common workplace areas, and talk about some best practices to be able to address these areas. Now, with respects to the human rights generally legally, the purpose of the human rights regime is to create an even playing field for employees and individuals who've traditionally experienced discrimination. And in the workplace, what you're required to do as employers is to be able to provide an inclusive working environment that's respecting the rights of individuals who might have differences and might be negatively impacted by these differences. So how is this particular purpose delivered? Well, it's done primarily through 3 key laws. The main one we know is the Human Rights Code. That's the granddaddy of them all. We'll spend most of this webinar talking about the Human Rights Code and specifically discrimination. There's harassment under the code as well, so do have that, keep that in mind. However, I'm really going to look at discrimination here because harassment is a growing area, and I think it almost needs a webinar of its own. Some things that employers don't realize is that other statutory laws do create obligations with respects to human rights. One of them is the Ontario Accessibility for Ontarians with Disabilities Act, AODA. All workplaces, regardless of your size, you should have emergency plans for employees with disabilities. And this means that if there is an emergency within your workplace and an employee with disability needs some level of accommodation, that you have a plan in place to address it. And this has to be a written plan and needs to be part of your AODA compliance. If your workplace is over 50 employees and you have greater responsibilities under AODA, you are also required to have individual accommodation plans for employees with disabilities. So that's a plan on how you're going to accommodate them, what those accommodations are, so that's documented. And if there's an employee who's on a leave of absence, you're required to have a return to work process and program for them. So those are the human rights requirements under AODA that specifically impact your employment or your workplace. The Employment Standards Act also has legal liabilities for employers with respects to human rights issues. The one that we all know of and is common top of mind is with respects to pregnancy. And as you know, as an employer, you're required to continue benefits for employees who are on maternity leave, so they can't be treated differently. And they are required or entitled to their job when they return from their leave of absence. And if their job no longer exists through a workplace restructure or something of that sort, that you have a positive obligation to be looking for a similar job for them to be able to return to. There are also a number of family leaves that are prescribed under the Employment Standards Act, and I think that this is an area that we're going to probably see a lot more litigation in future. So family leaves are becoming very big. People have responsibilities not only to care for their own children, but to care for their aging parents. And as a result, we see family caregiver leave, critically ill child leave, new leaves that were created in the Employment Standards Act. And these are job protected, where employees cannot be penalized if they are taking this leave, and they're entitled to their job when they return. So that's some of the other regimes where you do tend to find human rights creeping in, other than just the Human Rights Code. So I'm going to load another poll, which I'll get you to go ahead and answer. And I also should mention that with respects to the Accessibility for Ontarians with Disabilities Act, and also with the Employment Standards Act, I am going to have webinars that are specifically addressing those particular areas. So the webinar for July is is addressing the Employment Standards Act and some of the common enforcement areas. And of course, pregnancy leave will be one. And the August webinar focuses on AOTA, which is an area that people are often confused about. So I have a true-false question. If you can go ahead and answer that, I'll close the poll shortly. But I wanted to talk a little bit about the Human Rights Code. And the focus of the code is basically to prohibit discrimination and harassment based on protected grounds in a protected social area. And the social area that obviously concerns you and I is the area of employment. There are many other areas that are protected, such as housing, but as it pertains to you, it will be the workplace. So there's a misconception that with human rights legislation, that any type of discrimination basically offends the code. And I had a question from one of my clients the other day about a dress code policy and not requiring, or making sure people who have tattoos are covered up, and whether or not that would be a violation of the Human Rights Code. Understand that employers are able to legally discriminate. So those of you who answered true, you are correct. Employers can legally discriminate, and we discriminate all the time. We provide people in the same job with different salaries and sometimes even different benefits. And that discrimination is not an issue. The only time it becomes an issue, and it's a violation of the code, is where it touches on any of these prohibited grounds. So if you're treating somebody differentially simply because of these prohibited grounds, then you're going to be in violation of the code. But if you're treating people differentially simply because of skill level, or you're treating them differentially because of something that's not in the code, such as tattoo, piercings, other than ones that might be there for religious reasons, then there's no violation of the code. And those are workplace policies that you'll be able to support. Now, with respects to the Human Rights Code, it's important to know that you're not only looking at your workplace and employees. Your obligations under the code within your workplace extends to people who are even possible job candidates. They could be suppliers who are coming on your premises. So you have very broad responsibilities as employers, and you'll want to make sure that whatever policies you have in place, you are considering or having an eye on the greater workplace and not just the employees. And the areas that we tend to find the greatest number of complaints focus on a handful of issues, recruitment and selection being a big one, people not getting jobs because of the fact that they might identify with a particular group. Promotions and transfers, compensation and benefits is also another area. Dismissals and layoffs tend to be a very big area, especially as it pertains to disability and also with sex discrimination. Hours of work and scheduling with respects to some CREED obligations, performance management, and workplace policies. And I say workplace policies is where it really starts and ends with respects to issues. Now, with workplace policies, understand that not many workplace policies will overtly discriminate against a person. Sometimes a neutral rule will work to adversely impact a group. So for example, the dress code policy is one that tends to have adverse effects on individuals. I think we can all remember many years back when Mounties of Sikh faith weren't permitted to wear turbans, and so they brought a human rights complaint, and that was seen as a workplace rule, though not meant to be discriminatory, because there was a Mountie dress code that they had a negative impact on a group of people, and so the employer was required to find ways that they would accommodate and create more inclusive working environments so employees who were Sikh could continue to practice their religion and faith, and in a way that made sense to them and was also in accordance with the workplace philosophy that we do want people to be able to fully participate, and simply because you wear a turban, you can't be a Mountie. So employers' duties are, the main duty is the duty to accommodate. And the duty to accommodate is essentially your statutory requirements to be able to find ways to help a person participate fully within the workplace. And the duty to accommodate is, the goal is to eliminate barriers within the workplace and allow the full and active participation of individuals. Accommodation doesn't have a specific process, so the code and the tribunal doesn't define how accommodation should be provided. It is taken on a case-by-case basis, and it requires dialogue between you and the person requesting accommodation, and understand that there is an obligation, positive obligation as well, on the person requesting accommodation to be able to ask for, the needs that they have. So I have another poll that I ask you to answer. It says, an employer may be required to create a job where none exists in order to satisfy its legal duty to accommodate. So far, most people have answered false to this. If you can submit your answers now, I will answer this question. I think most of you have it right anyway. But with respects to accommodation, employees often get it wrong in terms of determining what they feel is a positive accommodation obligation. Employers really don't have to satisfy unreasonable demands, and accommodation doesn't have to be perfect. Let me just move my slide here. So some of the things that the tribunal has actually, let me just go back. I'm getting ahead of myself. Some of the things that the tribunal has discussed in terms of the restrictions or things that would be unreasonable for employers to do is something such as creating a job where none exists. There has to be some kind of benefit to the employer, so there's no requirement for accommodation to make work projects or busy work. You're not required to bump somebody out of a position to be able to accommodate an employee. You don't have to put somebody in a job that they're not qualified or they can't perform. And if the person's position becomes redundant, there is no requirement to take extra steps to accommodate them. So the duty to accommodate does not protect an employee from a layoff. And there are also limits on employers' duty to accommodate. The code doesn't say that you have to accommodate completely, but you just have to do so up to the point of undue hardship. And as with all things in the code, it's a contextual analysis what undue hardship is. There's not one single way of figuring out if it's undue hardship. There are some considerations that the code and the tribunal look at when assessing whether or not accommodation is reaching the level of undue hardship. The first being costs. So if it's going to be too costly for an employer to implement, then that might be a limit on the employer's requirements to be able to provide accommodation. And so an example I would use is if an employee has a mobility issue, you're moving into a new building, their team is now on the second floor, and there's no elevator, the duty to accommodate is not going to require you to put an elevator in. That would be way too costly. However, if you're on the first floor, the duty to accommodate might mean making arrangements so the employee has an office on the first floor, or even a flexible work arrangement so they can work from home. The other limit on an employer's duties within the human rights regime is where there is a bona fide occupational requirement that doesn't make it possible for the employer to accommodate. And there is an established test that sort of guides employers as to what would be a bona fide occupational requirement. So there's a legal test, and there's three pieces of that test. The first is that the employer adopted the standard for purpose that's rationally connected to the performance of the job. The second part of the test is that the employer has adopted the standard in honest and good faith, and it was necessary to fulfill a legitimate work-related purpose. And the last part of the test is that the standard is reasonably necessary to accomplish a legitimate work-related purpose. And the example I like to give is a pilot who is blind or becomes blind. And this particular pilot is looking to continue to work as a pilot. Well, sight would be B4 for the discharge of the duty of a pilot. So if you can't see, you're going to put yourself in danger, and you're going to also be putting the passengers in danger. So although the employee can be accommodated, maybe by looking at other opportunities within the workplace, they wouldn't necessarily have to provide that job or find ways to provide that particular job to a person. So that's an example of a bona fide occupational requirement. Now, I'm going to go through, the next series of slides will go through some of the areas that we tend to have most complaints with human rights. But I do want to say this, that discrimination tends to be very nuanced. And from what I've seen from assisting employers, employers have not at all engaged in active discrimination. They're not trying to, treat negatively an employee with a disability, or they're not trying to be difficult or take away a job for an employee who's gone on pregnancy for that particular reason. But what happens, because it's nuanced, is the employer has to prove if the employee is able to show differential treatment, the employer has to prove their reasons why the differential treatment was not discriminatory, and it becomes very, very difficult to do. And I say that although this area is growing and might seem overwhelming for employers, there's a lot that you can do to be able to comply with the code and keep yourself out of trouble. And a lot of it is just being live to the issues of discrimination, understanding where they might arise and being proactive in trying to resolve them. One of those areas is creating a policy, and we'll talk a little bit about policies. But if you have policies and systems in place to address discrimination, you're going to be far better off ahead when there is a complaint, or even to be able to address a complaint before it starts. The other thing is working in good faith with the employee to address the issues. Sometimes you might feel that the employee is just using the system to be able to, get some kind of favor. And I say that even if that is true, if you still work in good faith with them to be able to come up with accommodation solution, you might be able to flesh out those particular situations and stop them from happening if employees trying to abuse a disability system. And the last thing I was going to say is document, whether it's an accommodation plan that you're having for an employee, or conversations that you're having about accommodation, or even if there are reasons that you're treating them differentially and you want to be able to justify it, document those, because that will go far in being able to help you in future. Now, it seems as if most of you guys have policies in place. It's about a third, actually, it's a third for each. The Human Rights Code is constantly changing. There's new requirements. And I think that, again, to always be live to them, you should be reviewing your policies at least annually. I know, for example, with the Human Rights Code, a dress code has become an issue, and you'll want to make sure that you've gone through your dress code, see if there is any ways that it'll offend. Sometimes you might not even think it's offensive. The restaurant workers who are having women wear heels and skirts probably thought that was all in good faith, but the tribunal has now come down, or the commission has come down with a policy directive basically on dress codes in a restaurant service. So you'll always want to be making sure that your policies are complying, and annual review of them is the best thing to do. If you don't have a policy in place, you might have a great workplace, but the problem is, as soon as you have a complaint of discrimination, and the Human Rights Tribunal on their response form requests that they ask you, do you have a policy? If you say no, it seems as if you're more lax in your desire to address discrimination. And so that sets you behind the 8 ball, because that's going to be the perception moving through, even though that might not be the reality. So let's start to look at some of the areas that are big in human rights compliance in terms of employees bringing complaints forward. And the first one is with respects to sex. And sex also encompasses the, pregnancy, which is the greatest area that you tend to see this. And what I find is an employee goes on maternity leave. There's a replacement worker that's brought in. The employee might have had performance issues before they went on leave. The new person is working great, and now the employee's coming back, and they're like, okay, well, we would rather terminate this person because we don't want them we found better, so we don't want them to work here. So the reason you're terminating them is not because specifically of the fact that they've taken the leave, but because of performance issues before. And if those performance issues aren't documented, it's going to be far more difficult if there's a complaint to be able to show that you weren't discriminating based on the code. So that's where you typically tend to find pregnancy claims or sex claims under the Human Rights Code. I say, as far as best practices, and the best practices will be similar for many of these areas, but The first thing is to create a formal defensible job qualification, because another area that you find with sex discrimination is employees, young women who are in childbearing ages are overlooked or not supported, or even fearful that, you know, if they get pregnant, they're not going to have an opportunity, or they might think that their pregnancy impacted their ability to have an opportunity. So if you have a formal defensible job description with qualifications and a selection criteria, makes it far more easier for you to point to objective reasons why a person isn't able to have a job, rather than something that is a bit more loosey-goosey. There should always be a procedure in place for pregnancy and parental leave in terms of documenting when the leave is going to start, what the employee can expect during that leave, and how they're going to be returned to work. And if there is a need for modifications for breastfeeding or something as an employer, because sex includes breastfeeding, there would be a need to provide even a flexible arrangement to be able to assist the employee. The next one that I wanted to touch on is family status, and this is a growing area within human rights. You're seeing a lot more litigation here. And essentially, family status is defined as being in the parent and child relationship. And that's seen in a very broad way. So it's not just a parent and a young child, but somebody who might have obligations to care for ailing parents. And the problem with family status is that, you know, there's a belief that every single request for, you know, time off, coming late, whatever, it has to be accommodated. And that's not true. Obviously, you want to have a accommodation plan, but employer doesn't have the legal obligation to accommodate every aspect of a child care, elder care obligation. But you want the person to be able to participate as fully as possible. So if it means a flexible work schedule or alternative work arrangements, so they can come in later in the day if that need be, or leave earlier to be able to attend to an ailing parent or to pick up a child. The other thing I always say is a fantastic way to be able to manage these types of leaves is to offer personal days or unpaid time away from work. I talked about this in my April webinar. If you want a replay link for that, please email me. I will be happy to provide it. But personal days are a wonderful way to be able to have a general number of days available where people can use them as need be, and they're not being policed, and they're not banked necessarily. They're given on a year-to-year basis, but it gives people flexibility to manage their schedules. Moving on, another area is creed, and this also encompasses religion. Creed isn't defined under the code, but the courts and tribunals have referred to it as religious beliefs and practices. Understand that creed can also include non-religious beliefs or any kind of system that influences a person's identity or worldview. So if somebody is Wicca and they have some type of accommodation needs regarding like having to participate in Wicca ceremonies or something like that, then although it doesn't fall under traditional religion, you would be required to do so as an employer. One article I read recently was about veganism and how that might be an area under creed as well too. So it's an expanding area, but understand it's a strongly held religious or personal belief. Now, with these areas to accommodate somebody, again, review of policies and procedures, offering personal days off and unpaid time away from work, and flexible schedules and alternative work arrangements. And if you read the article that I had about the restaurant that closed in Toronto, that basically had violated or discriminated against Muslim workers, there's lots those employers could have done to put different systems in place to be able to address some of the issues that came out in that particular hearing. And the last one I'm going to discuss is disability. But this is a granddaddy one of them all as it pertains to human rights. And disability is defined very broadly to include both visible disabilities and ones that aren't visible. The thing about disability is that it should have some degree of permanence. So an illness is not necessarily seen as a disability under the code. So if somebody's sick, headache, stomach flu, not necessarily a disability. However, if there's some level of permanence with that particular illness, or if there's a perception that they're being treated differentially because of illnesses, then it might fall under the code. Disability is the area where there is oftentimes the greatest abuse, but I say that employers can do much to be able to limit the abuse by having formal policies and processes to be able to manage somebody who specifically requires time away from work or is looking for accommodation. Employers are entitled to reasonable information, not necessarily the diagnosis, but prognosis, and functional abilities, information about the individual's functional abilities that will be able to help them complete the role that they have. So there's lots that you can do with disability management. I will be providing a tip sheet that follows the webinar that gives you some more concrete best practices that you can look to implement in your workplace. So I know I've rushed through really quickly, but with that, what I'll do is start taking questions. Now, I don't see any questions right now, so if you do have questions, please go ahead. Is it possible, somebody has asked if it's possible to get a copy of the slides. And I will say that, yes, absolutely. The slides are in a Prezi presentation, but you will get a replay link. So the replay link will give you the ability to listen to this over again or share it with other members of your team. And I will also be giving you a tip sheet, like I said, so it's something that you can use as you know, a complement to your policies and procedures should you need to use them. Are there any other questions? I'll wait a few seconds because I know there's a delay. And while you are putting in your questions, if any, I'll let you know that the next webinar is July 21st, complying with employment standards laws. We're going to focus on some of the top areas in the ministry's enforcement. So we're all, or most workplaces are bound by the employment standards laws. You have to comply, so that would be worthwhile to attend. So a few other questions. Jenny says, is there a time limit in which a former employees can come back and raise discrimination as an issue? Yeah, Jenny, that's a very good question. There really isn't a time limit. Again, you want to show a rational connection between the whole notion of discrimination and the adverse impact. So if, let's say, an employee is returning from a pregnancy leave, for example, and a few months later they have lost their job and the person who is a replacement takes over their job, they can still bring a human rights complaint, nothing stops them, but hopefully the employer in that particular case will be able to document and show that the performance wasn't up to snuff and they would like to have somebody different, or that, you know, the job requires somebody different. And so that removes it really from just punishing a person because they were pregnant and took leave, and more dealing with something that is related to a bona fide business need. Hopefully that answers your question. And David says, in my pilot example, if I found a new position, would it have to be at the same pay? Interesting. That's also a very good question. There is a concept that's a little bit too complicated to get into, but it's called frustration of contract. And so in the pilot example, the pilot going blind is no fault of the pilot, but it's also no fault of the organization as well. And so if the organization had another job that was available but wasn't at the same pay level, the employer wouldn't be discriminating simply because they're offering the person a lower job or a lesser paying job. So in those situations, no, there wouldn't be a discrimination. There wouldn't be a legal requirement to, but in other situations there might be. So for example, if an employee is returning from pregnancy leave and their job's no longer available, you would want them to be able to participate in a way that's more fully. So if there's opportunities in the workplace that are at the same level, that's what I would recommend as an employment lawyer that you look to add in. And Carrie asks, are migraines considered a disability? Migraines could very well be considered a disability because even though a headache, or, you know, these are seen as illnesses and they're only, you know, sort of, they have some level of permanence, but, you know, are not, they're fleeting, they come from time to time. And as a migraine sufferer, I can say that, you know, it's not always that you're going to have them. If an employee has migraines and often has migraines, they would have to bring that to your attention, obviously, because you wouldn't be able to, you wouldn't have the duty to accommodate something that you don't know about. However, if let's say the days that they're having flare-ups with a migraine, they have a flexible work arrangement where they can work at home or come in a little late or even use a personal day or take it as unpaid time off without being penalized, that would be a accommodation solution. So yeah, migraines could be considered a disability. And if it has some kind of ongoing permanence, even though it's an illness, even if it's a flu or stomach flu somebody has often, could be considered a disability. And there should always be a plan to be able to address those issues. So with that, I wanted to thank you guys very much for your time. I know time is one of the most precious resources that anyone has. And so the fact that you spent this time with me this morning, I greatly appreciate it. Do look for the replay link and the tip sheets that will be coming into your inbox tomorrow. And I hope to see you next month at the webinar in July. Thank you.